Hi, my name is Adam Bergman, and I'm a partner with the IRA Financial Group, president of the IRA Financial Trust Company. Today, I want to discuss what is a disqualified person. Now, this is something that everyone who is using retirement money to make investments, alternatives, specifically alternative, should understand and know very well. And this is found under Internal Revenue Code section 4975E2. And another reason why you got to work with tax professionals like the IRA Financial Group to help you establish these self-directed IRAs. I'm an attorney, I'm a tax attorney, I have a master's in tax law. I've written 6 books on the topics of self-directed retirement plans. We have trained attorneys, CPAs on staff. Obviously, we're not a law firm, we don't give legal advice, but we can help you navigate these rules. So you need to have people that have a tax background helping you explain these important topics. The disqualified person is important because it will likely trigger whether you've encountered a prohibited transaction. So 4975 are really the rules that talk about prohibited transactions. And it basically comes down to this. You can't use your IRA any way that personally benefits you or a disqualified person. And a disqualified person is basically a lineal descendant. You as the IRA owner and your lineal descendants, your parents, your children, your spouse, daughter-in-law, son-in-law, any entities associated with such persons. So that's what a disqualified person is. So if your transaction does not have any disqualified people on the other side of it, you probably can do it. You may trigger unrelated business taxable income or some other tax pitfalls that, again, you want to work with trained tax professionals to help you navigate and make you aware of, but you're probably not going to run afoul to any of the prohibited transaction rules. The trigger is generally a disqualified person. So clearly you can't buy a house and live in it, or buy a house and rent it to your parents or children, your spouse. That stuff, the IRS is basically saying, listen, these disqualified people, these lineal descendants, we think they're so close to you that if you transact with them, it's like you're personally benefiting. And the IRS needs to protect their distribution rules. Listen, IRAs, $9 trillion in IRAs, $29 trillion in retirement accounts as of 2017. Huge industry, huge market. And if the IRS just lets people do whatever they want with their IRAs and 401ks, most of these are pre-tax. So what that means is when someone hits 70, they have to take what's called a required minimum distribution, which is essentially 3% of their account. Now, if they let everyone just give their money off to their kids or their spouse, no one's going to ever pay tax on these RMDs. They're just going to give it to their kids, give it to their spouse, buy their spouse a house, buy their kids a house, and that would severely impact Treasury negatively. So they need to protect these rules, and they're basically saying, listen, if you give your IRA to your parents, or if you buy a house and let your parents live in it, it's too close to home. It's like you're personally benefiting. We can't allow for that. So the key is understanding these disqualified persons, making sure they're nowhere near the transaction, nowhere. So if you buy a house, don't rent it to a lineal descendant. It's interesting enough, brothers, sisters, aunts, uncles, cousins, friends, they're good. They're not disqualified people. So you can transact with them. Business partners, you need to be careful. If you're in a business that you own more than 50% of and your partner is more than 10% interest, he or she could be a disqualified person. So you need to talk with a tax professional, help understand that situation in more detail and see if it violates 4975E. But essentially, stay away from disqualified persons. Even if they own 5% of the business you're investing in, you need to think about it. Now, clearly, you can buy Apple stock, Google stock, even though you own a few shares personally. Because it's so closely held, that's not going to trigger prohibited transaction rules. But if it's, in my estimation, a company with less than 100 shareholders, even if you individually own 0.5%, 1%, 2%, you potentially can trigger a prohibited transaction. There's a case, Rollins v. Commissioner. It's a 2004 tax court case. This gentleman, Mr. Rollins, used his 401k to lend money to a business he owned less than 10% of, was simply just a director, not an employee, and the tax court ruled it was a prohibited transaction. So even though you may own less than 50%, and a lot of people say, well, if you own less than 50%, you can do it. You can do joint ventures. The 50% is the cutoff, whether an entity is disqualified. That's not the case. Case law, like Rollins, has shown us that you can trigger a prohibited transaction even if you own a disqualified person owns less than 50% of that entity. So my position is if a disqualified person, and it's not widely held, it's not a public company, owns even 1%, talk about it. Talk to a tax professional, get his or her opinion, speak to a few. You're not going to get an IRS position on it. You're not going to, no one gets opinion letters on this stuff. it's too cumbersome, too expensive. But if there's any question, there's a disqualified person hanging around this, you probably don't want to do it. This is something I spend most of my day on every day, talking to clients, potential clients on transactions, helping them navigate these rules. They are complicated. There's a million types of scenarios you can go through. We got a number of common perimeter transactions on our website, but there's a million different scenarios. That's why you need to speak to people to help you navigate these rules. The key is you cannot personally benefit. You cannot have disqualified persons anywhere there. You can't provide services. You can't personally guarantee an obligation of your IRA, so no using your IRA as collateral on a personal loan. You can't get personally involved or personally benefit. Now, clearly, the distinction is you can buy Apple stock with your IRA, and Apple stock can go up. That's not a personal benefit. That's an IRA benefit. The IRS is getting that personal benefit when you take your IRA to go to Disney. That's a personal benefit. Take your IRA and you buy yourself a car. That's a personal benefit. Take your IRA and buy your kids a house. Kids are a disqualified person. That's a personal benefit. That's what the IRS is trying to stop, because they're saying, listen, if you want to personally benefit from your IRA, take a distribution, pay tax, do whatever you want with it. But if they don't protect their distribution rules, they're not going to be able to capture that revenue which they're counting on. So again, this is a really important topic. I can spend 5 hours on this topic. So if you have questions, call 800-472-0646. We can talk about your specific situation, kind of help you navigate 4975 more succinctly. Adam B at irafinancialgroup.com, A-D-A-M, B as in Bergman, Adam B at irafinancialgroup.com. Love to hear from you. Again, thanks so much for watching. Really important topic, and please call if you want to chat further. Thanks.